Hello, welcome everyone. This is the last in our series of 4 recorded webinars for people who are asylum seekers or refugees or migrants or who are supporting them. This one is on housing and tenancy rights. It's of broader interest and relevance than our previous ones. They were on citizenship applications by naturalisation and family reunification, and we had one on immigration statuses and stamps. So my colleagues Fiona McCall, Rachel Birmingham from Doras will once again share their knowledge and expertise on this webinar. And I'm delighted as well that we're joined by Chris McDermott of the Residential Tenancies Board, or RTB as it's called. And that's the body that regulates the rental sector. They also have a role in informing policy, resolving disputes between tenants and landlords, among other things. So I'm looking forward to this session. I'm glad to say that once again, we'll be making the information in the presentations available on our website in Pashto, in Arabic and in French, along with the other webinars in the series. So there's a lot to cover tonight. So without further ado, I'll hand over to Fiona first. As we go along, if anyone has any questions, do put them into the Q&A or the chat as we go along, and we get to them at the end. So over to you, Fiona.
Thank you, John. And thanks to everyone who's taken the time this evening to join us for our webinar, as John said, on housing and tenancy rights. I firstly would like to say a few words about Doras. We were established in the year 2000 to provide support specifically for asylum seekers living in direct provision in our area. And our office is based in Limerick City. Our vision is a society where equality and respect for the human rights of all people are realised. And our mission is to achieve this through personal and collaborative advocacy, the law, through intercultural dialogue, support, inclusion and empowerment, working at local, national and international levels. So this evening, we'll be focusing on 3 main areas. Firstly, we'll give an overview of the Housing Assistance Payment, commonly known as HAP. We'll then explain the difference between the HAP payment and other forms of social housing applications before going through the steps needed to actually apply for HAP. We will also look at what happens if your application is approved, including the landlord's responsibilities, and reasons as to why a payment for your HAP may be stopped. We will then look at what you should do if you are ever finding yourself in a situation of homelessness and in need of emergency accommodation. And then finally, we'll hand over to Chris, who will take us through an overview of the dispute resolution process within the RTB, the Residential Tenancies Board. And then, as John said, at the end, we'll give you a chance to ask any questions you might have. So, what is the Housing Assistance Payment? HAP is a state programme that helps families and individuals on low incomes to pay their rent. It's important to note that HAP is not the same as council housing, although you must apply through your local council for payment. HAP is a form of social housing that helps pay for the rental costs of privately rented accommodation. So how do you apply for HAP? To be eligible for this scheme, you must first apply for council housing and be added to the council housing waiting list on approval of your application. This application needs to be sent to the local authority in the area in which you live, or in the area where you can prove you have a specific connection with. The application form for council housing can be requested from your local council office or be found online. Applications are to be placed on the council housing list can take approximately a month to process. And once you are qualified for social housing support, You are then eligible to go ahead and apply for HAP. So to apply for HAP, you can make your application to the local council, as I said, once your application for social housing has been approved. HAP forms can be requested from the council, but only needs to be completed once you have found private accommodation suitable for your needs. There are several sections on the HAP form that require completing by the applicant as well as the landlord. There are also sections for revenue and social welfare payments information where applicable. It is important that all the sections on the form are filled properly before submitting the application form, and that you have also submitted the supporting documentation that is required for the application. So, what supporting documentation do you need? It's important to submit the PPS numbers of all your family members in your household. You also need to submit evidence of your Irish residence permit, also known as your GNIB card. You'll also need to submit passport or travel document as proof of identification, and also any evidence of a social welfare payment if this is applicable to you. You'll also need to submit certain information from the landlord of the property, and this includes the landlord's signature on the consent page of the application form, evidence that the landlord is compliant of tax, and this can be done by way of an e-tax clearance form, evidence of ownership by the landlord of the property, and finally, certification that the property meets rental accommodation standards. So now, what happens once your application for HAP is approved? The council will pay the monthly rent direct.
Fiona.
Sorry, the council will pay the monthly rent directly to the landlord. The amount is based on maximum monthly rental limits. However, the council does have a limited flexibility to exceed these rental limits. It's important to note that as the tenant, you'll be required to pay what's known as a weekly contribution to the council. And if this contribution is not made to the council, they can stop the payment of rent directly to the landlord. So it's really important that you keep up these monthly contributions, weekly contributions. The payments to the council for this contribution can be set up by a standing order direct from your bank account, or if you're in receipt of, say, a social welfare payment, you can pay it through the household budget scheme. So once you're in receipt of HAP, you do not need to remain on a social welfare payment. It's important to note that you can take up full-time employment whilst in receipt of the HAP. The amount of the HAP that you receive will be based on your total household income, which takes into account any income from any adult children living with you. It's also important to note that the council is required to inspect your property within, say, 8 months to ensure adequate standards are being met for that property. So now I'll hand you over to Rachel, who goes through further rights and obligations when in receipt of HAP, and then she'll talk you through what you need to do if you ever find yourself under the threat of homelessness and in need of emergency accommodation. And then finally, we'll hand the presentation over to you, Chris, who will cover an in-depth overview of the dispute resolution process with regards to the Residential Tenancies Board. Okay, over to you, Rachel. Thanks.
Thanks, Fiona. So we're just going to continue on here in the same vein if you are approved for HAP. So once you're in receipt, it actually means that the council views that your housing need has been deemed to be met. So what this means is that if you do receive HAP and you go to a landlord and you have HAP paid to your landlord, it means you're no longer on the waiting list for a full council house. So it's important that if you want to remain on the list, the waiting list for a council house, you can apply to remain on what is called a transfer list, and then you will be considered for other forms of social housing. So that is important to know. I think people don't understand that if you do get HAP, they do take you off of the council housing waiting list, which unfortunately is quite a long list to be on at the time being. So it's good to remain on it. You can expect to remain in the property for a minimum of 2 years once you're on HAP. And your permission to remove within that 2 years is only going to be considered on specific grounds. So if you are in the house for less than 2 years and you decide that it doesn't suit your needs anymore, it will have to be something very specific. For example, maybe medical issues that you've come across now. They don't really like you to be chopping and changing within that 2 years. We have a list here of some of the counties, the HAP limits. So this is how much HAP will pay for a property for you based on how many people you have applying for HAP. So you can see there in Limerick, if you are one adult and you're looking to share accommodation, so you're looking to move in with other people, Limerick will pay 270 euros, which to be honest is not a lot of money. So, but unfortunately these are the limits. You can see there we have Clare, Galway, Tipperary, Cork. This will all be in our translated documents as well. So you don't have to be scribbling it down now. You can also find more information on the rest of the counties on the Citizens Information website. So as we mentioned earlier, there are some reasons that your HAP can be stopped. We have seen this unfortunately a few times. If the accommodation does not meet the minimum standards which have been set out, they can stop paying your HAP for that. The landlord is not tax compliant or registered with RTB, they're not going to pay HAP then. If you as a tenant do not pay your weekly contribution, they will stop your payments. If you do not complete your rent review when your income changes, again, they'll stop your payments. And if you do not pay new weekly contributions, if your family size changes, again, they can stop your HAP payments and you can rack up quite significant arrears, which we have seen as well. So just to kind of, for the tenant side of this, it's mainly just to keep paying your contributions. If you receive any communication from the council saying that your contribution amount has changed and you're not really sure what it means, you can come into Doras, we can explain it to you and make sure that you don't end up in a situation where they stop paying your rent. Landlord responsibilities. So when you are being paid through, the landlord is being paid through HAP, they also have some responsibilities as part of the application process. They will have to submit a monthly rent amount, their bank payment details, give an undertaking regarding the property's compliance, and also an undertaking regarding tax compliance. So there are certain things the landlord will have to complete in order for HAP to be paid and to continue to be paid. There are some benefits for this for anyone who is listening who is a landlord who's unsure about accepting HAP. There's no need for rent collection, so it takes away that responsibility. You don't have to worry about that anymore. All payments are made electronically. Again, saves yourself a bit of hassle. Increased tax relief if you're renting to HAPs, so HAP tenants, excuse me, for at least 3 years. And your mortgage interest can be treated as an expense, which is great as well. So there are lots of benefits there. Just to say as well, if the tenant ever does have difficulty paying their rent, you will still get paid your monthly amount from HAP. So there's another benefit there that you don't ever really have that arrears problem that you could have from private payments. Move on now to an unfortunate part of the world at the moment in Ireland, homelessness and emergency situations. If you do find yourself in immediate danger of homelessness, just to let everyone know that you can access emergency accommodation through the council. I think sometimes there's a bit of confusion as to who can do this and who can't. The Homeless Action Team will assess your situation. If you're qualified, you will be offered emergency accommodation. And what I want to say here, just to really drill it home for people, is that everyone, no matter what your immigration status is, you are entitled to a 9 to 9 emergency bed for the night, regardless of whether or not you're on stamp 4, stamp 3, if you're in the asylum process, this is entitled to you. So it's not necessarily emergency accommodation as in a home, but you will have a bed for the night. And that is what 9 to 9 stands for. From 9 p.m. until 9 a.m. you can have a bed. So the Homeless Action Team is located there in John Square in Limerick. It's quite easy to find. I have the numbers there. So they have a normal 061 number for business hours, that's 9 to 5. If it's outside of that you find yourself in need of a bed, they have an 1800 number that you can contact. There are also a few other organizations working specifically in housing and if you are in danger of homelessness. So say if you get an eviction notice or if you have trouble paying rent, there are a few different places in Limerick that can assist you with this. I won't read them all off, but they will be on our website and they will be on the translated documents as well. So there's Threshold, Peter McVeary Trust, Novus, Focus, as well as MABS. Now, MABS is a money advice and budgeting service. So they would offer help to anybody who might be having difficulty kind of looking through their expenses each month and allocating money to rent, bills, food, etc. They can help you work out the best way to use the money that's coming in. And finally, we just have a list here of a few websites where you can get more information. There's citizens information, and I've just put the link there for HAP, the City and County Council in Limerick. Again, that's for their housing assistance payment. That's where you can find the forms themselves. And then there's also a hap.ie, which is just the Irish government website, which explains HAP. So if you want more in-depth information, you can look at those. And I think that's it now. If we want to hand it over to Chris to continue on.
I think you need to unmute, Chris.
Apologies, how are you doing? I'm not sure if I'm sharing my screen properly. Can you see that, John?
You are, yes.
Okay.
Yeah.
Firstly, thank you to John and the rest of the gang at Doras for inviting me to participate. I'm familiar with the excellent work that Doras does, so I'm delighted to be involved. So I'm speaking as a member of the Residential Tenancies Board. I'm one of their adjudicators. I have to say that any views expressed are my own rather than the board's, but I'm hoping that I'll be able to give you an overview of the role of the RTB in resolving landlord and tenant disputes, as well as a sense of the primary legal issues that arise and how they are dealt with under the Act. Just by way of context, the Residential Tenancies Board was established in 2004, and its primary role is to replace the courts in dealing with disputes between landlords and tenants in the case of residential tenancies. So it doesn't deal with commercial tenancies, but only residential tenancies. And I would, while the RTB, it sort of acts similar to the court's service in terms of facilitating the work of the courts and judges, the RTB is independent, so it won't provide legal advice to either party, but it does provide information. So if people have particular concerns, you should always feel free to contact the RTB. Their website is pretty comprehensive, and they do their best to disseminate information widely in relation to landlord obligations, tenant obligations, and what you should do if you have a dispute with your landlord or indeed with your tenant. Also, Threshold is a really good organization that have really specialist knowledge of this area, and they're only sort of too eager to help people who are in difficulty with their tenancies. So sorry, trying to move on to the next slide. It's not working for me. Okay, let's skip on to my section. Apologies. Okay, so in terms of what I'll talk about, I'll give you an overview of the responsibilities of landlords under the Residential Tenancies Act of 2004 as amended, the responsibilities of tenants, the rules relating to the service of notices of termination, bringing a tenancy to an end, the rules regarding the notices of a rent review, so increasing rent, and then the dispute resolution service. In terms of the dispute resolution service, just so you sort of understand how it works, if either a landlord or a tenant has a difficulty in terms of the tenancy contract, if, for example, it's a tenant, you simply contact the Residential Tenancies Board. They will talk you through the dispute resolution process, and if you wish, you can submit a dispute. The RTB offers a sort of two avenues by which the dispute can be resolved. They offer a mediation service, which is actually really useful and has a very high success rate, and that can be done over the telephone. So it's a telephone mediation service whereby I lodge a dispute against, for example, Rachel. They will contact Rachel, ask her does she consent to participating in telephone mediation. If we both consent, then a mediator will contact us both at a set time, and they'll dedicate about a 2-hour period to sort of going back between Rachel and myself and trying to resolve the dispute. The telephone mediation has a really high success rate, and there's no charge attached to it. If that's not an option, if the nature of the kind of relationship breakdown is such that mediation isn't an option, then you can elect for an adjudication. And that's where somebody like me will essentially hear the case. So both parties, if it's in person, pre-COVID, the hearings were always in person. Since COVID, they're virtual, so similar to this. But essentially, the person taking the case will be invited to speak first and to explain what the problem is. Then the landlord, if the landlord is the respondent, will then have an opportunity to present his or her case. The adjudicator might ask some questions. The adjudicator will explore the possibility of coming to a settlement at the hearing. And if that's not possible, well, then the hearing will end. The adjudicator will go away, write a report, and at the end of that report, there'll be a decision, a legally binding decision, which is enforceable. If you disagree with that decision, then you have the right to appeal to a tenancy tribunal. A tenancy tribunal is essentially the same thing all over again, the same type of hearing, but it's before 3 people this time. And there is no appeal beyond the decision of a tenancy tribunal. It is possible to go to the High Court on a point of law, but that's a separate matter and very unusual. It's important to note that the decisions of the RTB are legally binding and enforceable. So landlords are obliged to comply, or indeed tenants are obliged to comply, and enforcement proceedings can be taken against either landlords or tenants who don't comply with the decision of the RTB. So it is no longer an option to take your landlord or your tenant to court. You must use the RTB process. It's sort of exclusive. Okay, so in terms of landlord responsibilities, I'll just give an overview of them. And so if there's one point that I would sort of labour, it is if you are a tenant or if indeed you are a landlord, don't be afraid to lodge a dispute and to bring the case to the RTB. I think you will find adjudicators and tribunal members are quite supportive. There's a recognition that the parties before the either adjudicator or the tribunal are generally speaking not legally qualified. Sometimes they are represented by solicitors or barristers, but there's no requirement that you be represented, and they understand that often people are not represented and do not have a knowledge of this area of law. And they will talk you through the process. It's designed, while it is quasi-judicial, it's designed to facilitate lay litigants or persons who don't have particular legal qualifications. Okay, so what are the responsibilities of a landlord? Well, they are legally obliged to register a tenancy But importantly, it doesn't matter from a tenant's perspective whether I as a landlord registered a tenancy or not. If you are my tenant, you can sue me before the RTB even if I haven't bothered registering my tenancy. It'll just create an additional headache for me because the RTB can pursue me for non-registration and I can get a €3,000 fine as well as the case being taken against me by you. On the other hand, though, a landlord who has failed to register a tenancy cannot lodge a dispute against the tenant with the RTB. So if they want to lodge a dispute, they'll first have to register. And if they have registered late, they'll have to pay a late registration fee, and then they can pursue the case against the tenant. So registering your tenancy is a legal obligation for which there is a sanction if a landlord doesn't comply. But tenants' rights are not affected either way. Secondly, they must provide tenants with a record of payment. That generally doesn't arise in terms of legal disputes because most payments are electronic at this stage. You must provide tenants with a contact point. So if you're my tenant, you need to be able to contact me if there's a problem with the dwelling. And if the landlord doesn't provide a point of contact, that is a breach of the Act, for which if you sue me, you could be awarded compensation. I am required to carry out repairs and to maintain the dwelling. Obviously, if the tenant causes damage himself or herself, they're responsible for that. But when people are living in a house, ordinary wear and tear arises, and a landlord is responsible for that. Reimburse tenants for repairs which the landlord has been advised of but have not been carried out. So if, for example, you are my landlord and I say, look, the heating system isn't working, and you repeatedly ignore me, well, I have two options, essentially. I can sue you before the Residential Tenancies Board. The board can order you to carry out the repairs, and the board can award me compensation for the sort of discomfort in which I have been living for the last while. The other option is I can simply go ahead and pay for the repairs myself and then pursue you for the money afterwards if you won't reimburse me. Now, obviously, I can only do that if I have first notified you of the problem and you have kind of, failed, refused, or neglected to address the problem. So it's not that if I want a brand new nice heating system that I just go ahead and do it and then charge it to you. There'll have to be a breach of kind of the landlord's obligation first. You must give a written notice of any rent review. Ireland is now essentially sort of divided up into two parts. Some tenancies or some dwellings are in what are known as RPZs, rent pressure zones. If you're renting a house that is in a rent pressure zone, the rent can be reviewed every 12 months, but only but an increase of not more than 4% is all that can be imposed. If you are in a non-rent pressure zone, so an area that has not been designated as a rent pressure zone, well then the rent can be reviewed every 2 years and it can be brought up to whatever the market rate is. I'll talk more about that when we come to notices. Another obligation is if I want to terminate the tenancy, I must provide you with a valid written notice of termination. And there are really strict rules attaching to that. That is one of the sort of the consequences of the enactment of the Residential Tenancies Act of 2004 and the establishment of the Residential Tenancies Board. The idea was to professionalize the residential tenancy sector. For years, it had kind of been informal, where tenants had very few rights and landlords had very few obligations. This act is designed to professionalize it. So if I were a landlord, which I'm not, but if I were, and I wanted to terminate a tenancy, there's a really strict legal procedure in order to affect that, because obviously if I terminate a tenancy, that could have a massive effect on your life in terms of, your commute to work. If you've got children, they're in the local school, security of tenure is so important that the law does restrict the grounds upon which it can be terminated. I'll talk about those grounds in a few moments. If I want to inspect the dwelling, I can't just rock up to the house, knock on the door and say, hey, John, let me in, I want to have a look around. You have to serve a notice giving advance notice that I'm going to inspect the dwelling at a certain time. And even if I give that notice, I do not have the right to enter your house. You can still say no. Now, I have a right to carry out inspections. And if you are denying me that right as your landlord, I can take a case against you to the RTB. And the RTB can make an order that, okay, Fiona, you must allow the landlord in to inspect the house. But what I cannot do is just sort of walk into the house without Fiona's permission. Refund any deposit promptly. Deposit retention or alleged unlawful deposit retention is one of the more common issues that comes before the Residential Tenancies Board. Essentially, I have a right to my deposit back if I'm a tenant. And if the landlord wants to withhold all or part of that deposit, the burden is on them to justify why they are withholding all or part of the deposit. The grounds for withholding a deposit are rent arrears, damage beyond normal wear and tear in the property, utility bills in certain circumstances, unpaid utility bills, are this is scrutinized by the adjudicator or the tribunal, as the case may be, at hearing. But if you fail to give a proper notice of termination, if the tenant is leaving the dwelling and the landlord is left with a kind of vacant property for a certain period of time. But the burden is on the landlord to explain why they're not giving back the deposit. And lastly, to ensure the structure of the dwelling. In terms of tenant responsibilities, it's really important that tenants pay rent on time and in full, including during any process of dispute resolution. So for example, if I was a tenant in Fiona's house and the heating system wasn't working, so I say, Fiona, fix the heating system, and she ignores my calls. It is not lawful for me to withhold rent until Fiona fixes the heating system. I should continue to pay my rent on time and in full, and then sue Fiona before the RTB to get her to maintain the dwelling or to fix the heating system. But it's not permissible under the Act to withhold rent payments. Also, and I saw a lot of these cases myself, where I know Fiona and Rachel mentioned, HAP payments and the importance of paying your contribution. It's also really important, and they also talked about the importance of communicating with the council. So if the council give you a form to fill out, well, if you don't return those forms, they may well stop paying your HAP payments. Then very quickly your rent arrears will accrue. If the rent arrears accrue, then your tenancy is in jeopardy because the landlord can serve a notice of termination on the basis of non-payment of rent. And it's no defense to say, well, actually, I paid my contribution. It was the council that didn't pay theirs. That's absolutely no defense. If the contract is not, the council are not party to the residential tenancy contract. It is between you and the landlord. So if the HAP stop paying, it's your problem, not HAP's, if that makes sense. So it's really important to continuously communicate with the council to return whatever income assessment forms they require, to sign all forms, because otherwise the landlord could serve a notice of termination, and it's no defense to say, well, actually, I continued paying my portion. It was the council that stopped paying theirs. Now, I have seen cases where the council sort of stopped paying the HAP because forms weren't returned. Landlord served a notice of termination. The matter came before the RTB, and maybe the landlord might have said to the adjudicator, look, I'm happy enough for him or her to stay on in the dwelling, but I want the arrears cleared. And sometimes once the forms are returned to the council may well pay the arrears that sort of it should have been paid by them, if you know what I mean. But it's just really important that communication is clear and that you always remember that, HAP, the council, they're not part of this residential tenancy contract. They don't have the obligation to pay the rent, you do. So keep the dwelling in good condition, inform the landlord if repairs are required, and then allow them access to fix the dwelling. Inform the landlord of who's living in the dwelling, if people are moving in and moving out. If you want to terminate, you cannot just send a text and say, I'm off at the end of the month and I'm not paying the last month's rent. The deposit can cover that. The Act doesn't permit that. You have to serve a proper notice of termination on your landlord. Templates for all of these notices are available on the RTB website. So really, you just have to sort of type in your own name and dates and stuff. They have the templates there, but it's really important you do follow the correct template. To not allow or cause damage to the dwelling. That's relatively straightforward. Pay for any damage that is beyond normal wear and tear. This concept of normal wear and tear sometimes causes confusion. But if I can put it like this, let's say you have one person living in an apartment, renting an apartment on their own for 1 year. Or you have 6 people and a dog living in a house for 1 year. The wear and tear is substantially different. If 6 people are living in a dwelling and there's permission to have a dog and you have a dog, well then the wear and tear, the landlord must reasonably expect that there will be increased wear and tear than a single person living in the house on his or her own. So wear and tear depends on the duration of the tenancy and the occupation of the tenancy, you know, how many people were living there and how long they were living there. Like I've seen cases where maybe a tenant was renting a house for 10 years and then the landlord, you know, the notice of termination was served by the tenant, they were buying a house or something, so they were leaving. And then the landlord said, well, look, I need to repaint the place, so I'm not giving you back your deposit because there's wear and tear here. A landlord, for a long tenancy like that, the landlord would always have to give back the deposit because, you know, normal wear and tear over a 10-year period is substantial. There would be furniture need to be replaced, painting, all of that kind of stuff. So for, you know, just to bear in mind that normal wear and tear, while it is an ambiguous enough term, it's sort of, you know, influenced by the duration of the tenancy and the level of occupancy of the dwelling. Not to engage in anti-social behaviour or to allow others to do so, as in, you know, bringing over friends and having house parties, things like that. It's no defense to say, oh, my friend was singing at 4 o'clock in the morning, it wasn't me. You know, if you allow the antisocial behavior to occur at your dwelling, you're liable for it and you're placing your tenancy in jeopardy. And to comply with all of the terms of the tenancy agreement. Now, just to be clear, if I'm a landlord and John is a prospective tenant and I give him a tenancy contract, I am not allowed to write whatever I want into that contract. The contract must comply with the Residential Tenancies Act. So landlords are quite beyond what we talk about here. You know, you can. It is not really possible for landlords to impose additional conditions on tenants. The Residential Tenancy Act is sort of, if you like, it is creating the terms and conditions of the tenancy agreement. So if I were to sort of demand a year's rent in advance or something like that, that would not be compatible with the Act. But if there are other terms in the tenancy agreement, you do have an obligation to comply with those, as long as they don't in any way conflict with the Residential Tenancies Act. Okay, I hope that's not too confusing. So notice of termination. One of the central pillars upon which the Residential Tenancies Act is based is security of tenure. That basically means that if Fiona is renting a house from me, she has some security in that she knows I can't kick her out at a moment's notice. So the idea of a Part 4 tenancy is created by the Residential Tenancies Act. Just because it's Part 4 of the Act, it's known as a Part 4 tenancy. And it basically means that once a tenant is in occupation of a dwelling for over 6 months, that tenancy becomes a Part 4 tenancy, which means that the tenant can remain in that dwelling for a further 5.5 years. So 6 years in total. Now, there are, and I can only as a landlord, I could only terminate a Part 4 tenancy on one of 6 grounds. I'll talk through those 6 grounds in a moment, but they are very strictly interpreted by the RTB, and the burden of proof is on the landlord in establishing that the ground exists. So for example, if I am the tenant and Fiona is the landlord, and I'm in the house for a year, and then Fiona says, Chris, I'd like you to leave because I want to sell the property. Okay, she is allowed to terminate the Part 4 tenancy if she wishes to sell the property. But it's very easy for her to say she wants to sell the property, when in fact, maybe she just wants me out and she wants to up the rent and take in somebody else. The RTB are very aware of this reality, and so were the drafters of the Residential Tenancy Act. So Fiona bears the burden of proving that she does have an intention to sell that dwelling, and she has to serve me a notice of termination. She also has to accompany that with a sworn statement, so an affidavit, so a legally binding a document in which she is swearing that it is her intention to enter into a contract for the sale of this property within a period of time. Furthermore, if it turns out that Fiona doesn't get the price she wants, or if she doesn't sell it, she has to offer the property back to me. And if she doesn't do any of those things, then I can sue her for breach of my rights under the Act. So if it's the case that Fiona serves me with a notice of termination saying that she's going to sell the house, then, 7 months later, 6 months later, I spot the house up on Daft. They're renting, and Fiona's actually renting it to John for, a couple of £100 more a month. Fiona has breached the act in that circumstance. If she had decided not to sell the property, or maybe she never had the intention of selling it, whatever, she had a legal obligation to offer it back to me. She didn't do that, and I can sue her for compensation. The amount of compensation awarded by the RTB would depend on a range of factors. But one of the major issues that sort of, as an adjudicator, I would have looked at was, well, were there young children here that were relocated from one school to another? Did Fiona end up in, emergency accommodation for a while, pending finding new accommodation? What kind of mental anguish did this cause her? Because maybe her HAP payment was interrupted, she has medical conditions and she's registered with a local GP and now she can't get near that GP, and all of these other issues. Okay, so the Part 4 tenancy comes into operation automatically once the tenancy has been in existence for 6 months. So what then about a fixed term tenancy? If I give a 1-year fixed term lease or whatever, it doesn't matter. If I'm the landlord and Fiona is the tenant and I give her a 1-year fixed term tenancy, that tenancy becomes a Part 4 tenancy after 6 months, regardless of the fact that we've signed a 1-year contract. Okay, so you have the right to remain in the property for a further 5.5 years. So you have sort of security for 6 years. That's the idea. If you have not been in occupation for the required period of 6 months, then it's not a Part 4 tenancy. And that it's known as a Part 5 tenancy, effectively, and that tenancy can be terminated within 6 months by giving 28 days notice. Okay, so what are the grounds upon which you can terminate a Part 4 tenancy? So just remember, Part 4 tenancy, not that complicated, just means I've been living in the house for over 6 months. So, and Rachel is my landlord. So she can terminate that tenancy in one of the following 6 circumstances only. Firstly, a breach of tenant obligations occurs. So that's the first one there, a breach of obligations occurs by the tenant. The most common breach of obligation will be failure to pay rent. But it's not as straightforward as that Rachel can simply just terminate the tenancy because I miss a rental repayment. There are rules governing each of these 6 grounds. And whilst I have covered them to some extent in this presentation, I think I'll put you all to sleep if I sort of emphasize them too much. But if you are in this situation, please do refer to this presentation or to the Residential Tenancies Board. But essentially, if I fail to pay rent, Rachel is obliged to serve me with a warning letter that gives me a period of time in which to pay that rent. And if I don't pay it within the period of time, it's supposed to be a reasonable period of time. The word reasonable depends on the extent to which the amount of rent arrears, if it's sort of a small amount or a large amount. So breach of obligations by the tenant. So I haven't paid the rent. Fiona serves me with a warning letter. Generally, it's about 14 days. So it says, Chris, clear the arrears within 14 days, or I'll serve you with a notice of termination. If I don't clear the arrears within the 14 days, Rachel can then go ahead and serve me with the notice of termination. Another reason for terminating a Part 4 tenancy, or another ground, is that you require the dwelling for your own use or a family member. So Fiona is my landlord. She'd like to move back into the house, or she'd like to give it to her son or daughter or whatever. But again, there are strict rules governing this, because it would be quite easy for Fiona just to simply say she wants to give it to her daughter, but maybe her daughter has no intention of moving back in. So there are statutory declarations that must be signed. There's this particular notice that must be filled out. And in that notice, you have to specify, Fiona would have to specify who exactly is this person that's going to move into the dwelling and how long it is intended to occupy the dwelling for. And if it doesn't turn out that this actually happens, then the dwelling must be offered back to me. She wishes to sell the dwelling, substantially refurbish the dwelling, change the use of the dwelling. So, it was a house, but I'm going to convert it to office building or something. Or the dwelling is no longer suitable for the accommodation needs of the tenant, which might arise where the tenant has a number of additional children or something like that, and the house is no longer large enough. So, but in the key point to note that is in all of these 6 grounds, the burden is on the landlord to prove that the ground exists, and there are strict legal rules governing the service. So notices must be in writing, be dated and signed by the landlord or his or her agent. I won't read through all of these for fear that it'll put you to sleep forever, but essentially there are quite strict rules regarding what must be outlined in the notice. A fixed term tenancy is a little bit different. If a fixed term tenancy has been signed, so 2 years or 1 year or whatever, it can only be terminated where a breach of obligations occurs by either the landlord or the tenant. Or if, for example, I was a tenant and I'd signed a 2-year fixed term lease. Sorry, I have a child here in the background I'll try and get rid of. Yeah. Okay, love. Okay, love. Sorry, guys. So the landlord does not consent to an assignment. Essentially, if I had signed a 2-year fixed term tenancy and I wanted to leave the dwelling, well, I have agreed that I'd stay for 2 years. So as a tenant, how do I end that tenancy? Well, I can ask the landlord for permission to sublet or to assign the tenancy. And if that is refused, I can then go ahead and serve a notice of termination and leave, but only after I have first asked the landlord for permission to sublet or assign the lease. Okay. I've mentioned already the rent arrears warning, and I just wanted to give this by way of example. So obviously an obligation of a tenant is to pay all rent on time and in full, but if I don't pay the rent, it's not as simple that they can immediately terminate the tenancy. If Rachel was my landlord, she would first give me a 14-day warning letter, or it could be longer if there are longer arrears or higher arrears. So this is just a case study here. So a warning letter was issued for arrears of €2,066. However, a payment had not yet been applied to the account, and the arrears actually owed by the tenant were slightly less, €1,838.48. On this basis, the notice of termination was found to be invalid. Okay. Antisocial behaviour is another basis upon which you can terminate the tenancy. I've just mentioned there that antisocial behaviour is governed by section 17 of the Act. There's basically 3 paragraphs. The first 2 of the 3 paragraphs are really serious matters, like as in the tenant has engaged in some kind of criminality, or has caused, done something that caused serious fear to neighbours, in which case a notice of termination can be served that only provides a notice period of 7 days. So I had one case a few years ago where a lady, she was a tenant, and she was drink driving in the estate and had crashed into the wall of another house, and children were playing in the garden. So, that obviously was a really serious matter, and the landlord could terminate that tenancy with 7 days notice. But for less serious antisocial behaviour, like partying all night or something like that, which obviously does violate the rights of neighbours to peaceful enjoyment of their property, then it's a 28-day notice period. Okay, so if a landlord does wish to terminate a tenancy, a Part 4 tenancy, and has lawful grounds to do so. So one of the 6 grounds I've mentioned, that Fiona's a landlord and she wants the house back because she wants to occupy it herself, then she has to give a notice period that varies depending on the length of the tenancy. So I've listed the period of days required there. So if it's if the tenancy lasts longer than it has been in existence for more than 8 years, then it's 224 days at the moment. And there are full days, and that issues have arisen for landlords where they kind of miscount the number of days they're supposed to give. Okay. There have been a number of changes to the rules regarding notice of termination lately, and I'll just give an overview of them. Originally, the intention to sell was 3 months, so that if a landlord wanted to sell the house, they must have intended to enter into a sale within 3 months, and that's gone to 9 months. So the landlords must offer the dwelling back within 9-month period if the sale does not proceed. So they can leave the house on the market for slightly longer, if you know what I mean. If a landlord wants you out of the house because he or she wants to do substantial refurbishments on the house, the RTB scrutinised this very carefully. Substantial refurbishments would be something really big that requires vacant possession of the dwelling. So, you know, if the landlord says, I want to redecorate or put in a new kitchen or do some painting, that is not a valid reason to terminate a tenancy, and they won't get it. They wouldn't be permitted to do that. The substantial refurbishment is quite strictly defined. You know, it's something that basically, you know, you're pulling out all the heating system and you're putting in a brand new one, and it'll take weeks and that kind of stuff. The landlord or family wish to move back in or change the use of the dwelling. Just to bear in mind, if this doesn't happen, the landlord has an obligation to offer the tenancy back to the tenant. Another change is that it's no longer sort of just between the landlord and tenant anymore. If a landlord isn't serving a notice of termination on the tenant, they must also send a copy of that to the RTB. And additional damages can be awarded if this isn't done. So the RTB want to be on notice that a tenancy is being terminated. One change in the last sort of year or so, in order to make things a little bit easier on landlords, was there was a sort of an injustice where maybe a landlord served a notice of termination and gave sort of 250 days notice, but then realized, okay, I made a mistake, I miscounted the days, and you know, I should have given 251 days notice and I only gave 250. Those notices were struck down automatically by the RTB in the past, and the landlord would have to reserve that period of time all over again. Whereas now you can serve a remedial notice. So where there is no real prejudice to the tenant, if I have given Fiona 200 days notice and there was a slight error on the notice of termination, I don't have to start all over again. If you like, I can just serve a new one and just give her 28 days notice this time. It sort of addresses a kind of a perceived injustice that landlords were had to endure for some time. The notice of rent review, obviously rent going up is a major issue. It's become less of an issue since they created these rent pressure zones, but basically you need to, if you receive a notice of rent increase from your landlord, you need to sort of check whether or not his or her house is whether the house you're living in is in a rent pressure zone. If it is, then the rent cannot be increased by any more than 4% per year. And a review happens every 12 months, and a minimum of 90 days notice must be given. So if sort of Fiona moved into my house on the 1st of January 2020, and it's in a rent pressure zone, well, then I can serve a notice of termination on the 1st of January 2021, so 12 months later. But I must give her 90 days notice of this, so the actual rent increase won't occur for a further 90 days, if that makes sense. You also have to, there's a form you use, and it's not automatic that the sort of rent can be increased by 4%. It can be increased by no more than 4% and in line with market rates. So I will have to show, Fiona is my tenant and I'm the landlord and I'm increasing the rent in a rent pressure zone. I will have to show Fiona that rents have gone up in the area. And therefore I am imposing a rent review, increasing the rent by 4%. So how do I show rent have gone up in the area? Well, I have to submit to her, along with the notice of rent review, I have to show her 3 comparable properties. So notices from Daft or wherever you can get them, showing that rent in the area is X, you know, amount of per month. If you're not living in an area that is designated as a rent pressure zone, well, then the rent can be increased every 2 years only, but it can be increased in line with market rates, which could be more than the 4%. But there are very strict rules attaching to it. I would have to show, if Fiona was my tenant, I would have to show her, yes, okay, the market rate for this area is so-and-so. And I show that by having 3 comparable properties. And by comparable properties is something that will be scrutinized by the RTB. If Fiona is renting a 1-bedroom apartment from me, and then the comparable properties that I show Fiona are 4-bedroom houses, well, that's not comparable. You know, so it's similar sized dwelling. Okay, you can always get a list of the most or up-to-date rent pressure zones online on the RTB website, and the minister has the right to add new areas to the list all the time. So the RTB issues, you'll see it on their website, a quarterly rent index, and basically they're monitoring rents in areas. And if they think they're going up too high, then they notify the minister, and the minister can make that area a rent pressure zone. And their electoral areas is what they actually are. So it could be Galway City or Galway County. A number of properties are exempt, if you like, from the rent pressure zones, or sort of exempt in certain circumstances. One is if Rachel is putting her house on the rental market, but it's never been rented before, or it hasn't been rented in the last 2 years, well, then she's not bound by any 4% rule. She can just put it at market rates. And then after that, she's bound by the RPZ rules. So Fiona has a house, it's never been rented before. It's a 4-bedroom house in Dublin. She thinks the market rent is 2,000 a month, so she can put it up for 2,000 a month, or it could be 2,500 a month, whatever. The RPZ doesn't matter to her for until 12 months' time. Or if Fiona has rented for a while, but she took it off the rental market, carried out substantial change to the dwelling. And this is defined very, very strictly. So for example, she put an extension on the house, and now the floor space of the house is substantially different. Well, then she can breach the 4% rule. She can put on the extension on the house, put it back on the rental market, and she's not bound by the 4% rule. Immediately. She will for the first tenancy, but then she will be thereafter. I've given further details on this substantial change thing. So because it is strictly sort of laid out in the Act, because obviously, if Rachel was a landlord, she could say, oh, I've carried out substantial changes. I put in a new fridge and I painted the front of the house. That's not going to work. The Act is quite specific. Substantial change is defined as consists of a permanent extension to the dwelling that increases the floor area of the dwelling by an amount equal to or not less than 25% of the floor area, blah, blah, blah. So it's quite specific. Okay, I might, it just goes on further there that there's been kind of, really substantial change to the dwelling. Like the BER rating was D1 and you moved it at least sort of 3 degrees higher. That might constitute a substantial change. It does not require, importantly, it does not require work that is required to bring the property up to minimum standards. So there are minimum standards. If I put a house on the market, there are minimum standards applying to that house. And I cannot just say, okay, John, my tenant, I'm putting up the rent because I have put in a new heating system for you. But if the previous heating system wasn't working at all, well, then I'm just bringing it up to the minimum standards. So again, the burden is on landlords to prove. So if the tenant sues, if I'm the adjudicator sitting there and John is the landlord, it's going to be up to John to prove on the balance of probabilities. So more than 50%, if you like, a greater likelihood than not, that he carried out substantial change to this dwelling. So he'll have to come in with all the evidence. The tenant doesn't have to have any evidence, if that makes sense. John is the one claiming that he's not bound by the rent pressure zone because he carried out a substantial change to the dwelling. So it's John's obligation as landlord to prove that that is the case. There is a rent calculator on the RTB website. So because the 4% rule can get a bit complicated, like 4% isn't complicated, but it's 4% per year. So if there hasn't been a rent increase for 5 years, it could be 4% for each of those that is imposed. So anyway, the rent calculator is of use. Because obviously they're going to want to know what the previous rent was, but not only that, but when the previous rent was set. Because sometimes there's a mistake that I can increase the rent every 12 months. I can't. I can serve a notice of rent increase every 12 months, but that won't take effect for a further 90 days because I've got to give the tenant 3 months notice. So it's not quite as straightforward as it sounds. I'm coming to an end and I'm hoping that everyone hasn't disappeared off the webinar because I've spoke for too long. Essentially, in terms of the dispute resolution process, if I am a tenant, John is my landlord, either of us have a problem, but let's just say in this scenario, the tenant has a problem. I contact the RTB, they'll give me 2 options. Well, they kind of, when you contact them, they kind of encourage you towards the mediation option because it has a high success rate in the sense that when people come to mediated agreements, they tend to comply with them. So it's easier, there's no enforcement issues then, or there's less enforcement issues then. So anyway, you have a problem with your landlord, you have 2 options, mediation or adjudication. Mediation is where the matter will be resolved between you with the assistance of a mediator. So I have worked as a mediator in the past. So you ring the landlord, say what's the problem, ring the tenant, say what's the problem, see if you can propose a solution. And then I write up the agreement email it to both parties, they sign it. They don't have to physically sign it. By writing back saying I agree to be bound by it is fine. And let's just say it's, that the landlord will fix the heating system within 20 days. So I write up an agreement, both the landlord and tenant respond saying they agree to be bound by that agreement. They have a 10-day cooling off period, because obviously, you might sort of reflect on what you've agreed to and you may no longer be happy with it. So there is a 10-day cooling off period, but if neither party pulls out of that agreement within the 10-day period, the agreement is legally binding and enforceable. If mediation is not a reasonable prospect, you can apply for adjudication, and that is really where the adjudicator will make a decision and impose it on the parties. Decisions are, as in you generally don't get your decision on the day, because sometimes that would be a bit controversial and there's no sort of Garda protection available if they don't like what the adjudicator has done. So the adjudicator will write a report outlining the facts of the case. So Rachel said this, Fiona said this is the law, this is my decision. That goes to the parties. Parties will have a right to appeal that within 10 days. If neither party appeals within the 10-day period, then the adjudicator's decision is legally binding and enforceable, and the RTB has an enforcement section, and they will enforce it if necessary. Although in most cases it's not necessary, people just comply with the decision. If you appeal, then you will come here to this tribunal, and the case will be heard again by 3 members of a tribunal. They will also write a report, and their decisions are published on the RTB website. So if you really don't have a life at all and you want to read RTB decisions, they're all available on the RTB website. I've just given some sort of general information here that I won't labor very much, but here's sort of percentage-wise the most common disputes. Rent arrears, 26%, invalid notice of termination, 22%, deposit retention, 20%, 60% of cases are taken by tenants, about 40% by landlords, and 2% by other parties. The other parties would be neighbours. So I'm living next door to Fiona, who is renting the house, and Fiona is having parties every night of the week. So I sue the landlord, not Fiona. I sue the landlord because the landlord is not, I am alleging the landlord is not complying with his obligations to ensure that there is no antisocial behaviour occurring at the dwelling. Mediation, I've just sort of tried to explain the difference between them there, but mediation is free, quick, informal, over the phone. I'd very much recommend it, whereas adjudication is a little bit more adversarial. And telephone mediation, here's just some stats on it, which I think sort of shows the success of it. The RTB started this telephone mediation, and other agencies have kind of adopted it as well. But in 75% of cases, an agreement is reached, because the mediator can kind of say, like, when I did mediations, you might well say to the parties, look, the reality is here, the law is not on your side. So you can go to a hearing, but you'll lose. So what would be acceptable to you? And then you might kind of come to some kind of an acceptable arrangement. If mediation doesn't work out, then the matter will go to a tribunal hearing. And that is it. Thank you for your time. I would say if there are tenants that are in vulnerable situations, I really, obviously, if you can resolve, like maintaining the relationship, like a landlord-tenant relationship, it's more than a contract. It's a personal relationship as well. And if you can maintain a positive personal relationship, then that's the preference, So try to resolve matters informally with your landlord if they arise.
No, not at all. Thanks very much, Chris. Actually, 3 very informative presentations there from Fiona, Rachel, and yourself. Some very worthwhile advice and reminders, particularly for people who are renting or planning to rent. I actually learned quite a bit myself, I have to say, about the whole area of security of tenure, or tenancy in particular, and the rights and obligations of tenants and landlords. So thanks for laying it all out so clearly, Chris.